Well, yesterday we had on the program Missouri's Attorney General Andrew Bailey to talk about the oral arguments at the Supreme Court over the challenge to the Biden administration's social media censorship efforts. Well, the other leader in that challenge was Louisiana's then Attorney General Jeff Landry, who last fall was elected to serve as the state's 57th governor. He's also my governor. And he's here with me now in studio to give his take on yesterday's arguments and more. Governor Landry, welcome to Washington Watch.
Well, Tony, great to see you. Haven't seen you since the inauguration.
That's right. That's right.
I got some great pictures of you, too, by the way, that I owe you.
Well, good. I'm looking forward to it. I know you've been busy. I've been busy. But you came here to D.C. to be in the court yesterday to hear the oral arguments in this case that you and the Attorney General of Missouri pursued. Your thoughts?
Yeah, look, both Sharon and I went to the court. Certainly, I wanted to go and support our new Attorney General, Liz Muro, who I think is going to do a fantastic job in Louisiana on a case that you write that we started, both myself and then Attorney General Eric Schmitt, who's now a U.S. Senator, where we had believed, like many other Americans, like probably thousands or tens of thousands of Americans, if not millions, that during the pandemic and during the election cycle, their voices on their social media pages were being silenced, and that we believed that the government was involved in doing that as well. And so we filed this lawsuit under the presumption that the government cannot entice or coerce or force a private actor to do that which they cannot do, such as violate a citizen's First Amendment. And, a lot of people thought this case would go nowhere. Judge Doty took the case and did a great job, gave us some room for discovery. We found out all kinds of things, right? We found out that, in fact, the government knew that possibly the virus, the COVID-19 virus, came out of a lab in Wuhan. We found out that the FBI knew that they had the Hunter Biden laptop, and the New York Post article was not, in fact, Russian propaganda.
So the misinformation was actually coming from the government.
Correct. Correct. That's correct. We just found out countless things. And Judge Doty in the district court in Louisiana enjoined the government from continuing down this path. The Fifth Circuit took the case up. They agreed with him in part, narrowed the injunction a bit, and then the Supreme Court stayed that injunction and took the case up, and we heard it yesterday. The troubling part about yesterday's hearing, and of course I didn't get an opportunity to hear you and General Bailey's comments or his position, but what was troubling was how many of the justices who I thought could have understood and grasped the First Amendment and the government coercing social media to censor Americans, their questioning just didn't seem in line with that.
So, Governor Landry, I'm going to actually play a clip of Justice Ketanji Brown Jackson, who I think reveals the left's disregard for the First Amendment. Play clip number 3.
Some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information.
So if I understand what she's saying, the government has a right to silence you so they can protect you.
Well, let me tell you, sitting next to me was Congressman Jim Jordan and Dan Bishop. And when she made that comment, I thought Jim was going to get up and walk out. Because you're right, it was shocking. I don't know where she reads into either the Constitution or in the Bill of Rights where the federal government has a duty to infringe upon any American's civil rights or Bill of Rights, anything inside the Bill of Rights.
It's there for a reason.
Well, exactly. It's there to protect us from the government doing exactly that. And she continued to harp on, what if there's a compelling interest? But she seemed to gloss over the fact that before you can ask the question as to whether the government has a compelling interest to infringe upon your constitutional rights, you first must find that the government violated your constitutional rights, right? That's the first question. But she seemed to say that, listen, the government should have carte blanche to be able to infringe upon your constitutional right if the government feels
right.
that they compel to
And the
do so.
facts in this case, as we talked about earlier, show that the government was wrong. They were the ones putting out disinformation.
Exactly. And the fact that the justices didn't, or it seemed to be maybe that some of the justices who we thought were more favored towards supporting the First Amendment couldn't grasp that was a bit troubling. But look, I would hope that the line of questioning was simply to clear up some things, and maybe they did understand it. We will see. But I can tell you this, Tony. It is the most important First Amendment case in the last 100 years. There is no doubt that whatever the court does in this case is going to have an impact on American citizens and the relationship of the First Amendment to them.
So oftentimes when the court will ask these questions, it goes a different direction. So you can't always read into that. But might there be legislation that could come forth with all of the information that you've gathered through the discovery on this process?
Yeah, I mean, look, Congress could absolutely step in. I mean, look, it showed. I've been saying all along that Section 230 is problematic. Okay,
that's the section that gives the social media platforms immunity from being sued by private actors for whatever reason.
Correct. In my opinion, at this point in time,
that's a special status, by the way. That's a special status.
Right, one which this broadcast does not enjoy. Right, one which TV broadcasts, radio, and
so don't say anything. I'll get sued.
Right, what? That's why I'm here. I'm your lawyer too, right? But not anymore. I'm the governor. I can't be your lawyer. But look, you're exactly right. That's why I've been advocating for the fact that what should happen is those platforms should be dropped into the same regulatory bracket as broadcast.
Absolutely.
I mean, why is it that a little bitty radio station in Monroe, Louisiana, has to watch exactly what they put on or not, and the government can't call it. And then these social medias, they just have free reign?
Initially, it was to get them started, to help them, but now they're the giants. They don't need that special protection anymore.
I agree.
All right, Governor, we're out of time. I'll see you back in Baton Rouge.
All right, sure. Thank you for giving me some of your time, and thank you to all you listeners out there as well.
Always great to see you.
Take care.